Welcome to our lecture covering Chapter 5. In this lecture, we're going to discuss significant hospitality contracts. As you probably recall, in Chapter 4, we talked about contract law in general. We talked about the 4 elements of every contract. We talked about the UCC. We talked about preventative steps that you can take to increase the likelihood that you and the other side will stay in compliance with the contract. And we also talked about what happens when things don't go well and what the strategies can be in terms of the remedies that the plaintiff can be seeking and how that process might progress. Today we're going to look at just a handful of specific contracts that you're likely to see as a hospitality manager. Obviously, everything we talked about in Chapter 4 applies to Chapter 5. We're just going to get into a few more details regarding specific types of contracts. Okay, so we're going to talk about some contract clauses. You may recall when we were together last in Chapter 4, we talked about a choice of law and venue clauses, and we also talked about exculpatory clauses, and we briefly touched on indemnification clauses. We're going to talk more about those particular types of clauses and some additional ones. We're also going to discuss franchise contracts, management agreements, and also conference service contracts. So let's get started. Again, here are our goals for the chapter. Basically, this is just a repeat of what we were just talking about in terms of the topics for this particular chapter. So let's look at some particular categories of contracts. So in other words, we're going to drill in a little bit more detail about these 3 types of contracts and kind of develop a little bit of vocabulary about what we mean when we talk about these 3 kinds of contracts. Well, first of all, we have the franchise-related contracts. And here's the definition that we're going to be using in this course. Contracts that permit one business to use the methods and systems of another business. In other words, a franchise arrangement. We'll talk more specifically about what is a franchise and how it works as we progress in this particular chapter. Then we also have management operating agreements or management agreements. What are those about? Well, here's our definition. Contracts to establish a non-owner as the day-to-day manager of the facility. So here we're separating ownership from management. And we talked about this when we were talking about various business entities. You may recall when we talked about limited partnerships, how you had the limited partner who had limitations on liability but also wasn't involved, couldn't be involved, in fact, in the day-to-day operations of the business. And then we had the general partner who did not have any limitations upon liability but was involved in the day-to-day business. It's not the same thing as, but you can see some connections there. When we're talking about a management operating agreement, we're talking about the owner, and the owner might be an individual, it might be a corporation, it might be a partnership, it could be any of those business entities. But he is not involved, or it is not involved, or she is not involved in the day-to-day operations of the business. The management company, which again could be an individual, could be a partnership, could be a corporation, could be a company. So it could be any of those types of entities. It's involved in the day-to-day operation of the business. You can see how this can result in some tension because the owner might be interested in advancing one goal, whereas the manager might be interested in advancing a different goal. And so because of different agendas, different goals, sometimes there can result in some tension in the relationship. Obviously, that's not something that's ultimately beneficial to either party, but it's important when you're involved in drafting and complying with those types of agreements as you think through those issues. We also have management space contracts, and this is when, and you can see these 2 categories fit under this rubric of conference service contracts, that larger umbrella. So we have, this is again a full service hotel that provides space not just for hotel rooms, but also for conferences, for weddings, for things like that, spaces other than hotel rooms that it provides for rent. Obviously, usually there's people who, if you're renting space in the hotel, you're probably also renting rooms, but you may not. And then of course, both full service and non-full service hotels are going to rent lodging space or hotel rooms to people in groups. It might be the wedding party, it might be the convention group, and maybe the convention is happening in this hotel, but maybe it's not happening in the hotel. Maybe it's happening in the conference center or something along those lines. So you can see how a particular hotel might have both of these going on with the same group, or it might just have one or the other of these types of contracts going on for a particular event. Okay, let's talk about an operating agreement. This is a contract that details the areas of responsibilities of the owner of the business and the entity selected by the owner to operate the business. So this is relating back to the management operating agreements, when you've separated ownership from management. These agreements, as we said before, have the potential, if they're not drafted carefully, if they don't dot every I and cross every T, if they don't anticipate all the different issues that can come up, this can almost sabotage a working relationship. One of the things you want to do is make sure you answer all of the questions, anticipate all the problems, and as much as possible, align the incentives, align the motivations of both the owner and the manager so that they are as much as possible on the same page. If the owner is trying to emphasize one aspect and the manager is trying to emphasize another aspect, you're almost doomed to have some tension and some failures. And while some tension in the relationship is probably inevitable, a crafty drafter of the contract, and not just the word choice, but getting at the nuts and bolts of how the relationship is built, a crafty development of that can make really, really significant differences in whether it's going to be successful or not. Obviously, it should be very detailed. You should anticipate all of the various issues that might come up, things that you might not even think of you ought to be addressing. Let's talk about meeting planners. A meeting planners, in fact, this might be a career that you could be interested in. A meeting planner is somebody who organizes, who plans, who implements various meetings. This person is out there buying services for its employer or its client, however it's set up. So let's say that it's a meeting planner for I'm making up a name here, but the Travel Agent Society of America, and they've decided that they're going to meet in Phoenix, Arizona for their meeting. Well, and you're the meeting planner that has been assigned to lead the team. And so you're looking at renting space in the convention center. You're trying to decide how much space we need, how many breakaway rooms we need, how many hotel rooms ought to be reserved. You don't want to reserve too many because there's going to be a penalty if not all the rooms are taken, but you don't want to have too few reserved so that some of your members aren't able to secure a hotel at the right place at the right price. You'll also want to think through other aspects, maybe restaurants and catering and things along those lines. This is a career path that is certainly one that could be of great interest to the right person. It sounds like, or maybe it sounds like, it's fun. It could be fun, certainly, but it also requires a pretty savvy understanding of the market and also of business. I mean, you're not necessarily going to be having fun at the receptions. You're the one planning the reception. You're the one thinking through, well, are we going to have salmon or chicken? Are we going to have a buffet? Are we going to have a plated service? All of those choices. So it's reflecting business decisions, what's cheaper, what's going to be more pleasing to the customer, what's the budget, as well as what's meeting the goals of the client. So you have to really understand what your client wants, you have to understand the budget, and you have to understand how these services are going to be processed. Of course, if you're on the other end, if you are representing the convention center or you're representing the hotel or the other services, you'll be working with meeting planners. And, it's really not an adversarial relationship for the most part. They want to use your hotel, probably, and you want them to use your hotel. And so there definitely is a meeting of the minds. Of course, the meeting planner wants to get the best deal possible. He or she wants to pay the least amount of money for those services. And of course, on the other hand, you want the reverse. You want them to pay the most that you can expect them to pay. And so, yes, so there's some areas of common interest and there's some areas of differing interest. And so you're dealing with professionals in this area who are savvy, who are sophisticated, and obviously you're going to have to match their level of sophistication and savvy to get the best deal for your client. But you don't want to sabotage the meeting planner because you want him or her to think well of your hotel or your convention center and want to come back and use it in the future. Planning these types of events, the meeting space is an important function for a full-service hotel. If you don't book up this meeting space, then again, once a day passes and you haven't rented that space, you can never get that income stream back. Now, it may well be that the grand ballroom, it's unlikely you're going to be able to rent on the average Tuesday afternoon. So might be certain spots in the hotel that are mainly used during the weekends, but you don't want weekends to pass when you're not using that space, because once that weekend goes by, you'll never get that weekend back to make money off of. And of course, perhaps even more important than that, if people are using your meeting room space, they're probably also renting the hotel rooms. So there's definitely a synergy. You might cut a deal on the meeting room space because you're anticipating those people who are using the meeting room are also going to be renting the hotel room. So you might think of this as a package deal. A loss leader situation, maybe like Kroger might sell its milk at a low price in its circular that it distributes to the newspaper, hoping to draw more customers into its store that particular week, maybe customers who otherwise would have shopped at Walmart or Tom Thumb or something like that. And then, of course, once the shopper comes into the Kroger, the shopper doesn't just buy milk, he also buys eggs and bread and ground meat and all the other things, and those items aren't particularly placed at a low price. So that taking a little bit of a less profit or even a loss on a particular item can actually result in more business and more income and more profit for our business. And the same thing can apply in the hotel and hospitality industry. Here's some interesting information about the Meeting Professionals Organization, a professional organization, and it's called Meeting Professionals International. It's not a small group. Obviously, this is a growing area where business people are getting more and more sophisticated about how to wring as much savings as possible out of the meeting process that obviously is necessary really for any business to have meetings from time to time. And so you might, if this is a career path that interests you, you might find it interesting to go to this website to do a little bit more research into this field. Okay, so now we've talked about the generic definition of various terms. We're also going to talk about contract clauses, and this let me just flip back here. We're now going into kind of this category, contract clauses that we commonly use in the hospitality industry. So let's consider the term clause. What is a clause? Well, the definition that our textbook provides, it's a distinct contract provision or stipulation. Typically in a contract, you find that the paragraphs are numbered. This makes it easy to find a particular item in a contract, because after all, people don't sit down and read a contract like they would read, a murder mystery novel. You don't start with paragraph 1 and read through paragraph 419. You go to the portion of the contract that's meaningful for you. And, honestly, the writing in a contract is sometimes difficult. And so you don't even really want to read a whole page that you don't have to. So you don't want to say, well, turn to page 47. You really want to say, turn to paragraph 219 on page 47. And that focuses the reader on that discrete part of that page that's relevant to whatever you want to talk about. So numbering paragraphs is a tool to focus the attention. It allows you to tell the housekeeping department, this is the paragraph you need to focus on, or tell the catering arm of your hotel, this is the section you need to focus on. Because after all, we don't want the caterers or the housekeeping department to read a 100-page contract every time a new meeting contract is developed. And so you want to be able to focus the attention, make the bite that those individuals need to read as small as possible, and so as discreet as possible. So you want to have clauses that are relatively small, relatively tight, that are addressing a discrete issue, and that can be forwarded on to the folks who actually need that information. So again, contract clauses are typically relatively short, typically less than a page. Many times you'll have 4 or 5 paragraphs on a page that are numbered. And usually it's numbers, not letters, but sometimes you can have letters. The problem with letters is that usually you're going to have more than 26 paragraphs, and so it becomes more challenging after you get beyond 26. Oftentimes, paragraphs will also have a name associated with it. So, for example, let's say you have an exculpatory paragraph in your contract. So you'd say, you'd have the number say, I'll make something up here. We'll say that the paragraph is 119. And then you will have exculpatory clause. I'm not going to write out the whole word, but exculpatory clause. Then you'll typically have a period, and then you'll actually have the language in the paragraph. Many times this title might be in bold or might be underlined or might be in italics. It's a way to kind of focus the attention of the reader. So as he's skimming the contract, his eyes are drawn to the paragraph titles. There may even be a table of contents or some kind of index associated with the contract to allow you to quickly find those items. Also, many times these contracts are not going to be printed out and presented to people that way, but they're presented to people in electronic style, so it's quite easy, to do a word search to find the word exculpatory or whatever the word is that you're looking for. So these kind of bite-sized pieces are a big function or a big part of contract review, contract consideration, contract negotiation. And so it's helpful to be familiar with what a contract clause is and how it is typically going to be formatted within your contract. Oops, sorry about that. Let me go ahead and get rid of the format. Okay, so now we're going to look at some clauses that you might see in a contract. Here we go, that are involved in providing services, because a hospitality business is oftentimes going to be providing services. A room for a guest, a conference space for a guest, food for restaurant patrons, access to a hotel or to a spa or to a fitness area, dry cleaning services, those types of things. This is when the hospitality business is providing stuff, we'll say, to other people, usually the end users, the consumers, the guests, the patrons, whatever you want to call that particular person. And so let's look at some common clauses that you're going to have in these contracts. One thing to keep in mind is most of the time in these situations, if you're not dealing with meeting planners, of course, you're going to find that the contracts that you present to the guests, they're not really going to negotiate over. So you can make these contracts putting you in the position that's best for your particular employer in terms of how these are going to be set up. Now, maybe the specifics, for example, what the room rate is, that you may have to be flexible about, but the actual terms, the legalese, so to speak, of the contract, the individual hotel guests are not likely to quibble about that very much. Again, meeting planners might, but if it's just a one-off situation, if it's, for example, the bride and groom, or if it's, great Aunt Maybelle who's planning the reunion for the Smith family, for example. She may be concerned about what the room rate will be, but she's not concerned about exculpatory clauses or things along those lines. So let's see some issues that you'll want to be sure that you're addressing through that contract. Well, one is the length of time the contract price terms exist. So how long will these terms be available to the consumers? For example, you might enter into a block set of rooms for hotels. And let's say this family is planning on needing, we'll say 20 hotel rooms. We'll say it's for a wedding. And so you might guarantee a certain price on the hotel rooms. We'll say $125, even though these rooms usually sell for $200. But people have to commit to pay for those prices within the next 30 days. The wedding is 6 months off, but you want to have a commitment from individuals. And if they don't sign on the dotted line, so to speak, within 30 days, then the price goes up to $150. They can still rent the rooms, but they're going to rent it at a higher price. So that would be an example of how you'd want to set that out. And you might have multiple time periods with multiple contract prices. And so that kind of sets that up. Another example would be an expiry date on a coupon. Let's say you are a restaurant business and you're finding that you don't have as much business on Tuesday nights as you would like. And so you decide to run a special. Every Tuesday night in the month of November, you're going to do a buy one, meal get the second meal at half price. So obviously you won't be able to take advantage of this on Wednesdays or Mondays, and you won't be able to take advantage of it in October or in December. It's focused on those terms, but you'll want to be careful when you write that contract or that offer to make it as precise as possible so that the reader can immediately know what the terms are. You want that precision for a couple of reasons. Number one, if it's tight, if the language is clear, it's going to be less likely that someone's going to be able to legally challenge you and say, wait a second, I should have been able to use this contract at a different time. So you're insulating yourself from some legal exposure. But honestly, with respect to coupons, that's probably not your greater concern. Your greater concern is maintaining a good relationship with your customer. If you have a tight, well-written, clear, easy to understand coupon, and then when someone comes in and tries to misuse it, you can point them to the language, and they're going to perhaps think, oh my gosh, I misread it. I'm sorry. Yeah, you're right. I can't use it on this date. But if it's murky or unclear, then they may look at it and go, well, why can't I use it? It's ambiguous. My interpretation is just as reasonable as yours. And then you have to make a decision. Do you agree to what the customer wants, or do you say, no, we're not doing that? And you possibly might lose a customer. You might even get a bad Yelp review, or you might get somebody who won't ever come back to your particular business. And so better to avoid, better to be preventative, to anticipate the questions, to write it in as best possible way so it's as precise and tight as possible, so there will be fewer problems. That's one thing we want to achieve, but that's not the only thing we want to achieve. We want to identification of who is authorized to modify the contract and require that modifications be in writing. So let's go back to Great Aunt Maybelle, who is setting up the family reunion for the Smith family. Well, let's say that Bob Smith calls up and he says, well, you know what? It looks like we need 5 more rooms. Instead of 20 rooms, we need 25 rooms. Well, you don't know Bob. Is Bob Great Aunt Maybelle's husband or son or second cousin once removed? You don't know. You don't know if Great Aunt Maybelle is on board with what Bob is saying or not. And so you need to have figured that out with Great Aunt Maybelle when you got started. Hey, who can modify these terms? Who has that authority? And you want to make that explicit, express, written out very clearly in the terms of the contract. Because if you allow Bob to alter the terms of the contract, but it ends up, oops, wait a second, he wasn't supposed to do that, well, Great Aunt Maybelle may not be too happy with the change in the terms of the contract. She may even say that the Smith family isn't bound by those terms. And of course, it's best to take any modifications, whether they're made by Bob or Maybelle or by anybody else, to get those in writing. You want to have the entire agreement in writing, of course, but you obviously want to have any modifications in writing. So you have a clear paper trail of what was agreed to, when was it agreed to, who signed off on it, and what specifically those changes entail. You know, you're going to be dealing with dozens of these contracts, perhaps more than that. And if it's a meeting planner, he or she might be dealing with dozens of these types of arrangements. To expect people to remember exactly what was agreed to quite a bit after the time, that's not a very realistic assumption. And even if everybody could have perfect recall, people have their own self-interest. Sometimes it's not advantageous for them to remember the facts as we remember them. But if you wrote it down, when you have a record, the record's pretty powerful evidence about what the parties actually agreed to. Another thing you're going to want to think about is deposits and cancellation policies. Let's say Great Aunt Maybelle reserves 20 rooms, but it ends up that they only need 17. Some of the family members weren't able to come after all. Well, what are you going to do with the 3 extra rooms? When do those need to be canceled by for there not to be any type of a fee associated with it? If they aren't canceled by that date, what is the fee that's going to be associated with that? With the need to cancel those rooms. And obviously this is going to turn on how soon before the event the rooms are canceled. If it's weeks or months before, it may well be that the hotel can go ahead and sell those room spaces to somebody else. But if it's the night before everyone's arriving, it may not be possible to resell that space for that particular night. And so those are factors you have to think about as you write your contract. And finally, you may want to have a deposit. That makes sense. I mean, Great Aunt Maybelle wants to reserve 20 rooms. Maybe she wants to do that during one of your peak seasons. Maybe your hotel is on the beach somewhere in Florida, and she wants to reserve the space for the first week in July 4th weekend. incredibly busy time. Well, you're going to want to deposit a pretty significant deposit probably from Great Aunt Maybelle to make sure that she's serious about it, and also if she ends up backing out, at least you've gotten some money from that particular situation. Many times these amounts are going to vary depending upon the season. For example, if Great Aunt Mabel wants to have her family reunion in the middle of October, a time where your hotel just isn't very busy, you might be more willing to forego or reduce the amount of the deposit, and reflecting the different economics of the particular transaction. We'll talk more about allowable attrition, but it relates back to this whole cancellation idea. Great Aunt Mabel reserved 20 rooms, but she may not know precisely how many people are going to be interested in coming to the reunion. Or it could be, we'll go back to the bride and groom situation. Larry and Samantha are getting married. They are inviting 200 people to their wedding. Many of those people are couples, so they don't think they need more than 100 rooms. Now, of those 200 people that they're inviting, some are not going to come. Some are going to stay in larger groups than just two people in a hotel room. Some are going to be staying maybe with family or in other hotels that might be less expensive, perhaps even more expensive. And so when they reserve 100 rooms, it may well be that only 50 of them get taken. Well, if you have blocked off 100 rooms and you don't know that they're being canceled until right before the wedding, you're not going to be able to fill those rooms. And so you'll want to have a system set up so that, hey, you need to cancel any extra rooms by this date, or if you don't, then there's going to be this fee associated with this, or this fee associated with this. And of course, what you're focusing on is making sure that you're maximizing the use of your rooms at the highest rate you can for that period of time. Because again, once that day is over and you haven't sold that hotel room for that night, you'll never ever get that opportunity back. It's gone. Okay, so we've talked about the first things that we're looking at when we're providing services or products to guests. Let's go to our next slide. We also want to look at indemnification for damages. Let's say that we have a coat checking service that we're providing for guests at our fancy restaurant. When I come in my coat, it's cold, it's wintertime, and I don't want to have to put my coat at the back of my chair. It's a fancy place, so I check it at the coat check room. Maybe I pay for this, maybe I don't, but in any event, I want to make sure I'm getting back my fancy coat at the end of the evening. And the hotel or the restaurant is providing me with the service by providing a place for me to check my coat. But naturally, the hotel is probably concerned about, well, what happens if somebody steals the coat or injures the coat? Maybe pours something on it, maybe takes the wrong coat, maybe who knows what happens. And so under those circumstances, the coat check place concession might provide some language about indemnification, something like, the owner will indemnify the coat check place for any damages associated with that particular coat. After all, I could bring a coat in that is already torn or damaged, and it's a relatively discreet damage. It may be something that the coat check person doesn't even notice. And then when I come back 2 hours later to pick my coat up, I could put on my jacket and say, oh my gosh, look at this horrible tear. And the coat check person will be like, well, I don't know how that could have happened. I mean, I was here the whole time. Nobody came in. Well, my coat didn't look like that when I arrived. And how could the coat check service prove that, in fact, the coat was already injured before the person showed up here? So you can see how there can be issues when you're providing services like that. You want to make sure that you have some system of handling the risks associated with that. Now, you may decide that it makes sense for you to accept any kind of the responsibility for any kind of damage that particular coat or umbrella or whatever might experience. But you'll want to be clear about that. You want to cover those terms very specifically. Let's say that you are renting a space. We'll go back to Jack and Samantha, the bride and groom. And they have decided to rent, we'll say 100 rooms in your hotel. That's what they're expecting, 100 guests to be interested in renting space. Well, of those 100 guests, there may be a few people that get a little rowdy. I mean, after all, it's a wedding, champagne is flowing, good times are being had. And so it might be that a few people get a little bit crazy, a little bit of rambunctious, and they do a little bit of damage to the hotel room or maybe to the ballroom or whatever. Well, who's going to be responsible for that damage? I mean, it may not be possible to know exactly which guest, threw up on the drapes or broke the mirror in the bathroom or something along those lines. And so ideally you want to be able to associate those damages with a particular person so that the hotel doesn't have to swallow those damages. So you might want to have a clause in which somebody is indemnifying the hotel or the restaurant for any damage that might happen. Now obviously the person who's providing the indemnification isn't too thrilled with this idea. I mean, he doesn't want to be responsible for somebody else's screw-ups. So this is going to be a source of negotiation back and forth. We also have payment terms. Obviously, you as the provider of services or products is interested in getting paid. That's why you're providing this service. So who is going to be responsible for paying? How much are they going to pay, and when do they have to pay it? So again, going back to Larry and Samantha, our groom and bride, they're probably not going to be paying for all the hotel rooms. They may be paying for their own hotel room, possibly one or two other people, but for the most part, it's going to be the guests who are paying their own hotel room. I mean, it would be lovely if you could persuade Larry and Samantha to pay for all the hotel rooms, but that's probably not happening. Then, of course, you're going to be talking about, well, what's the amount of the fee associated with each hotel room? And you might be offering a variety of rooms, maybe some of a king-size bed, maybe some of a queen-size bed, maybe some of 2 double beds, maybe some are suites, maybe some are having a view of a particularly lovely part of the hotel area, maybe they're over the swimming pool or something along those lines. So there might be a range of fees associated with that. Also, when is payment going to happen? Is it going to happen after the person is being prepared to leave the hotel after the wedding, or it's going to have to be prepayment? And when does the prepayment occur? So all those are things that can be negotiated and that should be very, very clear under the terms of the contract. Also, we want to have performance standards in the contract. Sometimes this is hard to quantify. I mean, how do you quantify how good a meal is? Let's say that you're the hotel and you're catering the wedding, and you can have a contract that says, yes, there will be salmon, there will be mashed potatoes, and there will be green beans. Let's say those are the what should be on the plate. But just saying that there's salmon, or maybe it's going to be wild salmon, but that doesn't tell you that it's not going to be dry as can be, or it could be lovely, cooked in a very lovely way. So it's hard to quantify how tasty is the salmon going to be, how tasty are the green beans going to be. But you certainly can get at things like, is it farm-raised salmon or wild salmon? How many ounces are in the salmon? What are the ingredients in the mashed potatoes and the green beans? What type of sauce goes on the food? So you want to be as specific as you can to make sure that, to the extent you can control, you're getting as close as possible to what you want. If you're Larry and Samantha, of course, but also if you're the hotel, you want it to be as clear as possible so that Larry and Samantha have realistic expectations. I mean, if they're expecting, a 15-ounce salmon fillet on everybody's plate and you're thinking 7 ounces, well, you're setting yourself up for a bad event. That doesn't really advance your interest to have a dissatisfied people under those circumstances. So here's an example of language that you might use about performance standards. The hotel will prepare to serve 5% more guests than the contracted number. So let's go back to Larry and Samantha's wedding. They're planning to having 200 guests at their wedding. At least that's their initial prediction. But they get several regrets cards. And so it now looks like they're really looking at 160 guests. And so they've, of course, reduced the amount of tables that they're going to have at the reception, reduced the number of plates that they need for their sit-down dinner. Well, when it actually comes time for the wedding, it might be that fewer than 160 show up. Maybe there was a storm somewhere where planes were canceled, or someone was sick or something along along those lines. But it could also be the reverse. It could be more people showed up than 160. Maybe some people who initially gave regrets were able to come after all. Or maybe there were a few people that didn't have the option of a +1 who brought a +1 after all. And so you might even find that you have more than 160 that are actually being served. And so typically in these contracts, the hotel is going to contract to actually be prepared to serve 5% more. So if it's 160 they started with, then we'd be looking at, I guess, what would that be, 8 more, ballpark? Anyway, yeah, I guess eight. So they'd be prepared to feed up to 168 people, than what they have contracted for. That could be one provision, but Larry and Samantha might know that their guests are especially quirky and maybe more likely to bring extra guests than average. So they might want to make that 10. Obviously, the hotel's happy to accommodate that. But of course, Larry and Samantha are going to pay more money under those circumstances. So there's lots of provisions. Both parties have to think through exactly what's going to meet their interests. If you want something, it's probably going to cost you. So let's talk a little bit more about attrition. We talked briefly about it over, where was that? Yeah, here we go, allowable attrition. Let's talk a little bit more about this because this is a really important concept in hospitality law. So what is attrition? It's the reduction in the numbers of projected participants or attendees. Actually, this is the definition you need for this class, but of course attrition can apply outside of the hospitality industry. It's a term that is not necessarily tied just to this industry. This is whenever the number reduces or gets lower as a result of, it can be a biological process, or in this case it's not a biological process, but just fewer people show up than was expected. I mean, it's hard to predict when you're planning a wedding how many people will show, or if it's a conference, how many people will show. There's a lot of variables associated with that, and you do the best that you can, and many times you'll be close to being correct, but heck, there's a blizzard. Well, that's going to change the number. Or something else happens that might cause the number to fall or to rise. So one of the important terms here is what is the allowable attrition? Because we all know, or we all think it's likely that that number is going to fall. I mean, if Great Aunt Maybelle has 40 family members that she anticipates going to this event, and they are all couples, well, she knows the maximum number of people that are going to rent, or the maximum number of rooms she's going to need is 20. She might need all 20, but probably somebody, and she doesn't know who, but probably somebody's going to get sick or have some conflict or need to be somewhere else, or there's going to be a storm or something. So it's possible she's going to need all 20 rooms, but it's probably more likely than not that somebody's going to have something come up. But she doesn't know whether it's going to be one couple or two couples or three couples or seven couples. She doesn't know. She can give a guess, but Great Aunt Maybelle is probably not a professional meeting planner, and so she's just giving it her seat of the pants approach. So you're going to set up, you working with Great Aunt Maybelle are going to set up an allowable attrition, which says how much that number from 20 can fall before there's going to be some penalty. So let's say each one of those rooms is going to be selling for Great Aunt Mabel. Let's assume that she gets 20 rooms. But each one of these rooms are going to be for $130 a night. And as long as Great Aunt Mabel or her group rent at least 17 rooms, they're going to get the $130. But if we get below 17 rooms, if we're 16 or 15, then the rate is going to go up. And it may be that it's something that each one of the rooms goes up, or there's some kind of equation that somebody has to pay for that increase in the amount of rooms. So it's built in the amount of attrition. Now let's assume that Great Aunt Mabel is thinking she needs 20 rooms, and this reunion isn't until 10 months in the future. Well, unfortunately, 2 weeks after she makes this plan, somebody contacts her and goes, hey, you know what, we're just not going to be able to go at that point. We're expecting a child right around that time, and we just won't be prepared to travel with a newborn. So she knows right now, okay, I'm down to 19. Well, at that point, the hotel is going to be able to book that room because they've got 9.5 months notice. And so they're going to be able probably to say, okay, the allowable attrition early on, there's going to be more opportunity for attrition, because the longer notice the hotel gets, the more likely the hotel is going to be able to rent those rooms to somebody else. But if lots of people want to cancel their room, the night before or the week before, then that makes it much more difficult for the hotel to go ahead and sell those rooms. So that's how attrition works. So it's an important thing to include in the terms of the contract. And of course, the attrition rate and how that's calculated might vary depending upon the time of the year. If the attrition rate is, you might be more concerned about an attrition rate during a slower time of the year, because you might find it more difficult to rent those rooms. On the other hand, you might be so thrilled to get business during that time, you don't want to push too hard against those people that are interested in renting rooms. And so you kind of have to balance kind of who has the power under those circumstances, and you have to debate whether you want the business, even with the possibility that there might be greater attrition, or whether you want to perhaps not take that risk. Okay, now we're going to flip it and we're going to talk about the purchase situation, because hospitality businesses aren't involved simply in selling stuff. They also buy a lot of stuff. I mean, think about it. If your hotel is catering the wedding for Larry and Samantha, they're going to have to go and buy a lot of salmon. They're going to have to buy a lot of green beans. They're going to have to buy a lot of tablecloths if they don't already have it. They're going to have to buy mashed potatoes and champagne and iced tea and all those other things. So they're buying, hotels buy bed sheets, restaurants buy all the food and the silverware and all of those things. So again, when you are in the hospitality business, yes, sometimes you are selling stuff and selling services, but sometimes you're buying stuff and buying services. So you might buy a lawn service. Maybe you don't actually employ the groundskeepers in your particular location. Maybe you don't have a lot of grass, and so you decided to hire a service. That's fine. You're going to need to pay for that service, and you're going to have a contract to work out those specifics. So now we're looking at this, and this is typically going to be looking at business-to-business transactions, because you're purchasing things. I know this is phrased in kind of an odd way, so I'm actually going to cross this out because it's not necessarily the best way of saying this. You're typically going to be purchasing services from other businesses, and again, you're going to repurpose whatever that service or product is to the benefit of your guests. But typically this is going to be a business-to-business transaction. So when you're purchasing products, you're purchasing it from another business. And for example, you might be purchasing the food from a fishmonger. Or you might be purchasing the lawn service from a business that, landscaping business that actually takes care of land. And so these are more business-to-business situations. So it may not be automatic that you're the one drafting the contract. Depending upon the sophistication and size of the business, they might have some kind of set contract they ordinarily use. So this is a little bit different in terms of who's actually drafting the document. In other cases, though, you may well be the one who is drafting the contract. So there's a little bit more give and take in terms of the terms of the contract when you're looking at purchasing products and services than there might be when you are interested in selling products and services. Of course, one thing you want to look at is, what are the payment terms? When do you have to pay? If you don't pay right away, are there going to be some kind of fees associated with that delay in payment? All of those factors you'll want to look at, and obviously there's no perfect answer to this. Maybe your business model at your hotel is pay quickly and pay completely, and so then therefore you may not care about penalties and things like that, but you expect, because you're paying promptly and completely, that you get a bit of a break on the overall price. On the other hand, your hotel might be more interested in paying an extended period of time. And so under those circumstances, there may be concerns about interest rates for unpaid balances. So part of it's going to turn upon the financial status of your hotel, the business model of your hotel follows. Which one of these things are most important? If you insist, though, upon favorable terms on one of these elements, just keep in mind you're probably going to pay more for some other part of the contract. Obviously, you're going to want to nail down what the delivery or the start date is. If you're having, that fish, that salmon delivered for Larry and Samantha's wedding, and the wedding is on Saturday, you don't want the food delivered the day after the wedding, right? That's not really going to work for you. On the other hand, you don't want it delivered 2 weeks early because, after all, fish doesn't stay forever fresh. And so you'll want to nail down the specifics about that date. If it's a service, you may not be focused so much upon the delivery, but on when that service is going to start, because it might be ongoing. I mean, it might be a one-off situation. For example, you might hire painters to paint a particular room, and maybe it's the reception area that's going to look a little bit less than bright and lovely. But it might be a service that is ongoing. For example, a lawn service. Maybe during the spring and summer and early fall, you have grass growing all that time, and so twice a week you may want the lawn cut. Well, you don't want to hire a lawn service every single time it needs to be cut, but you'll want to establish a start date and a completion date. And of course, in this situation, you may not know exactly when the completion date is going to be, because depending upon weather conditions, it might be that the growing season is longer or shorter than it has been in the past. And so you'd want to set up some kind of provision in the contract that establishes, for example, you might say something like completion date will be based upon, when the grass has stopped growing at a certain rate, or be based upon when the owner of the business or the manager of the business would like to discontinue the service for that year. There can be lots of different ways of phrasing that. But you'll want to make sure that you've worded it carefully, ideally so that you, the manager, has the most control, because you don't want to be paying for someone to mow the lawn when the grass isn't growing. On the other hand, you don't want the contract to be ended and you still have grass that's growing, and then you have to enter into another contract. Sometimes contracts are going to self-renew. This could be, again, a lawn service situation. If you don't, let's say you hire Bob's Lawn Service for this summer, and he does an okay job, but you're really not sure who you want to go with next year. But you know what? You didn't read the contract closely enough, and so his contract automatically renewed for the next year, even though he wasn't the best. You're stuck with him next year. But if you had looked at the language in the contract, or maybe changed the language in the contract, perhaps you could have more easily gotten out of the terms of that contract and been able to choose a better service for the next year. As always, you'll want to provide performance standards. Of course, again, these can be difficult to write, but you might want to establish things like, how the lawn is to be edged, how the grass is to be bagged, where the blade should be, set up, how close to the ground should the blade on the lawnmower be, what type of lawnmower should be used, what type of fertilizer or other various chemicals ought to be applied to the lawn, those types of things. When should they be applied? So you'd want to be as specific as you can with the lawn service. You'd also want to be specific as you can relating to the salmon. If there are different grades of salmon, you'd want to, for example, identify what those grades might be. So let's go to our next slide. Many times, particularly when services are involved, there may be licenses required. For example, let's say that one of your air conditioning units is on the fritz. Well, you'll want to have an HVAC technician come out and address it, somebody with a particular license in that area. And so you'd want to make sure that that person has a license. Now, typically, it's going to be the responsibility of the service provider to confirm that his or her employee actually has the required license. But you might want to include in your contract that the only representatives of this business who will be allowed to come out to service the air conditioning will be HVAC technicians who are licensed in this particular state. So you'd want to make sure that the appropriate licensing is happening. But let's flip it up a little bit. Let's talk about, let's say your hotel has a salon service provided. And in that salon service, you have people who do nails, who do massages, maybe who style hair. Under those circumstances, in order to perform these services, these particular employees need to have certain licenses. And so you'd want to be sure that whatever licenses are required for those people are in fact provided. That's not really, I mean, it is an issue with the contract, because if Sally is giving someone a massage and she doesn't have the requisite license in your state to perform those services, and as a result of her providing the service, she injures somebody, that person sues. Well, the fact that Sally doesn't have the right license is a pretty darn bad fact. Even if Sally really wasn't responsible for the injury, is a jury going to believe that if Sally doesn't have the right credential? Probably not. So you'd want to make sure that whatever licenses the people who are in your employ or who are your independent contractors actually have the required licenses. And this would also fit in the area of permits. If you are getting, for example, an addition put on your building, you'll want to make sure you have the requisite permits to go ahead and proceed with those improvements or whatever it is. And we've already talked a little bit about indemnification. We've got a little bit more information in the next slide. And then there can be non-performance clauses. This would be, here we go. What is a non-performance clause? Well, these clauses explain what will happen if one party does not fulfill his or her duty. So this is basically a breach clause. So let's say that you've hired Bob's Lawn Service to mow the lawn, and it's supposed to be out Monday before noon and Thursday between 1 and 4 p.m. That's the schedule, and you've specified in the contract the particular services that they ought to provide on Monday and the particular services they ought to apply on the Thursday date. This is the maximum season right now for lawn growing, and so by Monday it's getting to be a little bit longer than you would like. But anyway, Bob doesn't show up on Monday. His service doesn't show up on Monday. His service doesn't show up on Tuesday either. It's beginning to look not so great. It's not the image you want to create for your hotel. It's already Wednesday and it's really looking bad. You don't have lawnmowers in your supply area because you have always hired this function out. It's now Thursday and you really have to mow the lawn, but you know what? Bob doesn't show up again. It's Thursday afternoon. He's missed 2 sessions. What's going to be the repercussions of this? You may be looking at hiring another service, but maybe that this time of the year, the best lawn services are already booked up and they're going to charge a premium to come out and mow the lawn. And so you'll want to figure out, well, can you have a provision in the contract that's going to make Bob responsible for paying that premium to these other lawn services? So you want to think through, what are the actual costs to your business when the other guy doesn't perform? The lawn service, or it could be the caterer who doesn't provide the requisite meals for the wedding, all of those things. One thing that you might have is you might have a dollars per day provision. That can be one way of addressing this. And of course, these are, by the way, these are liquidated damages clauses. This is another term we talked about in our last chapter, where you establish what the penalty is going to be, or at least discuss what the penalty is going to be if there is a breach. You hope there isn't a breach, but addressing what's going to happen if there is a breach is actually a preventative step. When both parties know what's going to happen if there's a breach, it oftentimes motivates parties not to breach because they understand, okay, this is going to cost me. I don't like that. I'm going to go ahead and do what I'm supposed to do. So in a dollars per day, you might have a provision that Bob, every day he doesn't mow the lawn, let's say you pay him $500 for mowing your landscaping twice a week. And if he misses the Monday, he's going to have to pay $50, or he's going to get $50 less if he comes on Tuesday. So instead of getting $500, he's going to get $450. Well, that's pretty motivating for Bob. He's going to try to be there on Mondays if he at all can. And that kind of resolves your issue too, because while you don't want him to be late on Tuesday, it's kind of nice saving $50. And so you might kind of balance it off. Well, the grass is looking a little high, but I did save $50, so it's kind of a balance there. And then finally, when you're purchasing services, you're going to want to consider dispute resolution terms such as ADR. You may recall we talked about this in the last chapter. Alternative dispute resolution are things like negotiation, mediation, arbitration. Oftentimes in the contract itself, you'll discuss how you're going to resolve a dispute that might happen when a party breaches. Are you going to use the court system? For example, that might be a choice of law or a choice of venue clause. Or you might say, look, we agree that we're going to go through arbitration, for example. Again, it's very common in business-to-business situations to go ahead and have an arbitration provision. There's pluses and there's negatives associated with this, but it's certainly a common choice to make. And probably it's a good idea before you set up those types of contracts to talk with an attorney about the advantages and disadvantages to those various approaches. Okay, so now we have, oops, I have a typo here. I have an F missing. I apologize. Let me just go ahead and add that in. I'm not the world's best typist here, so I'm just going to put in an F right here, indemnification. So what is indemnification? Well, here's our definition. We've had a similar, we had the word to indemnify earlier. Indemnification, to make one whole, to reimburse for a loss already incurred. Okay, so let's imagine that you hire an electrician to come in to rewire one of your hotel rooms that had some problems. And you pay them the money. They are an electrician, a licensed electrician. They say everything is good. You go ahead, you have the inspection. Everything seems to be working fine. You rent the room to somebody, to one of your guests. The guest stays in the room. Well, the guest there's a surge in the electricity. The guest experiences a burn as a result. Of course, the guest is going to sue the hotel, but if you were smart, you would have included an indemnification provision in your contract with the electrician, because after all, it was the electrician's job to make sure that any repairs were done safely and that really did resolve the issue. You're not an electrician. You may not even have an electrician on your staff. You're trusting that expert, that licensed person, to address that issue. It's obviously appropriate for the guest to sue you because you are the person who provided the room to him or her, but you'd want to have an indemnification clause that would say, hey, you know what? Ultimately, it's the electrician who's responsible for that. So that would be a clause that you'd want to have in the contract. Obviously, it's a very technical area. You're going to want to have attorneys involved in drafting that language. Okay, we've already talked about, I guess we don't need the F there, do we? We've already talked about exculpatory clauses in our last here we go. In our last chapter, chapter 4. So what is an exculpatory clause? Well, it's a clause in a contract that releases one of the parties from liability for its wrongdoing. The example that I gave was, trying to remember what my example was. Oh yes, the example was if you signed, you had an exculpatory clause in your hotel space rental, let's say room rental with a guest, and the guest, the provision says even though the guest is paying $400 a night, the maximum the guest can sue you is $50, no matter what happens. And he turns on the shower, acid comes out, he's badly burned, he has medical bills of tens or $100,000. Will the courts enforce that kind of exculpatory clause? Probably not. Courts are reluctant, especially when the power between the hotel and the guest is so out of balance. After all, the hotel has the ability to kind of know what the risks are, has the ability to hire attorneys to draft this type of language. But it can still make sense to think about these types of clauses. For one thing, it discourages litigation, and for another thing, sometimes courts will enforce it. So here's an example of a clause that you might have that is exculpatory. Operator, and this might be the hotel, is not responsible for items left in the meeting rooms overnight. So let's say that you have rented out 3 conference rooms to some kind of conference that's gotten together. And during the day, they have various presentations. People go out to eat dinner, they go back to their hotel rooms, and the next day they get started again. Because people know that they're going to have this room the next day. And many times people feel like, oh, I'll just leave my notebooks here, or I'll just leave my whatever here. And the next day they come in, it's not where it was left. They think somebody stole it. Who knows who stole it? Maybe it was a visitor to the conference. Maybe it was somebody in housekeeping or a stranger, who knows. But in any event, it's missing, and they now want to find the hotel responsible. And of course, the hotel might be skeptical. Maybe there never was anything. Maybe this is all a story. But if you have something like this in the agreement, you're saying, hey, you know what? If something is missing from those meeting rooms, we're not going to pay for it. So, I mean, you can leave stuff here, but if it's gone, too bad, so sad for you. I mean, you're not saying it that way, but that's the gist of it. So we have now covered exculpatory clauses. And now we're up to franchise contracts. We're going to stop here. Let me just flip back over here to the very beginning. And we have now covered specific contract clauses. We've touched on some of these other topics as well. In our next lecture, we'll discuss in more detail franchise agreements, management agreements, and also conference service contracts. So be on the lookout for the second lecture in this series. I hope you've enjoyed this presentation and found some value in it. As always, if you have questions, don't be shy. Come and email me, or alternatively, oops, I'm sorry, I went too far, or send me, or come on my office hours, I'm sorry, and we can talk about this in more detail. Thank you for your attention, and have a wonderful day.